State and this honorable court.
Good morning. Our next case is Cohane versus the Home Missioners of America. I'll note again that Justice Riggs is recused in this case as well, and we will hear from the appellant.
Good morning, Mr. Chief Justice and the members of the court. May it please the court. My name is Joshua Davey. I'm with the Troutman Pepper Law Firm in Charlotte, here on behalf of the appellants, the Roman Catholic Diocese and the Glen Mary Home Missioners. I represent the Roman Catholic Diocese of Charlotte, and my co-counsel, Mr. Steve Epstein of the Pointer Spruill Law Firm here in Raleigh, represents Glen Mary. And I'd like to reserve 5 minutes for rebuttal if I could. Your Honors, I think it's appropriate to acknowledge at the outset both the importance of the aims of the Safe Child Act and the gravity of the issues before the court and all of the cases that are before the court today, including this one. Important for the victims and the plaintiffs who brought these cases, for the defendants who are facing 20, 30, 40, 50-year-old claims, and for our judicial system as a whole, as the court has to weigh grave issues of constitutional and statutory interpretation. We're asking the court to reverse the Court of Appeals decision in this case because the Court of Appeals decision failed to faithfully apply the plain text of the revival provision of the Safe Child Act, which does not extend to the claims in this case. And so the question before the court in this case, in addition to the constitutional question that was argued before, is what is the meaning of the phrase, a civil action for child sexual abuse in section 4.2b of the statute, the revival provision. To answer that question, the court starts with basic canons of statutory construction. First and foremost, plain meaning governs. The court must interpret the statute in accordance with its ordinary meaning based on its text in context. The court has long held that to be the case. And if that meaning of the text read in context yields an unambiguous answer, then the inquiry ends there. This plain text analysis also means a few other things. It means the court should give effect to every part of the statute. It means that the court should interpret parts of the statute dealing with the same subject matter as a whole, ensuring that different words used by the General Assembly in the statute are given effect and given different meanings. And the court should interpret the statute in a way that avoids a serious constitutional question, if possible. So how should the court apply those canons of construction to the revival provision at issue here? Again, that provision purports to revive civil actions for child sexual abuse. For, as used in that provision, designates the kinds of civil actions that fall within its scope. It indicates the purpose or the goal of an action. And we know this, for child sexual abuse, and the phrase child sexual abuse is not defined in the statute. But we can refer to other provisions of our law. For example, Chapter 1, Section 2 of our general statutes, which defines the term action to include an ordinary proceeding in the court of justice by which a party prosecutes another for the enforcement or protection of a right or the redress or prevention of a wrong. And because we have recourse to the ordinary meaning and to the meaning of the term as defined in our own statutes, it's not necessary to, for example, find an ambiguity in the statute before the court can apply these canons of construction. And it's also not necessary to resort to dictionary definitions, which are frankly not that useful for a versatile word like for. So as a matter of plain text and common sense and the way it's used in our own general statutes, for, when used in the context of a legal claim like this, refers to the conduct for which the relief is sought, like a claim for breach of contract. And if we were talking about a claim for breach of contract, you might have a claim against...
Let me stop you there because that's where there seems to be a flaw in your argument, is that, so if I look at the complaint in this case, the complaint in the McKinney case that we just heard, or the ones that are coming up in the afternoon, I'm not going to see when I look down that complaint and you get the causes of action, I'm not going to see one that says something like second cause of action, child sexual abuse. and all of them see the same things, which are common law tort claims for assault, battery, intentional infliction of emotional distress, and so on. So if what you're saying is it only applies when there's some civil action that brought a claim for that thing, then even against the perpetrator, it wouldn't apply because there's no such thing as a tort claim for child sexual abuse. So it must mean something other than that, right?
Well, I don't respectfully, Your Honor, I don't quite agree. I think you've hit on a fair question, but I think the difference is that when we talk about for child sexual abuse, you could have different causes of action that are for child sexual abuse against the perpetrator. There might be a battery claim.
Right, and so let's say we say that. We say, okay, so it means claims that are for this thing that happened. Well, as I understand the allegation, the complaint, the argument is that there was a child who suffered child sexual abuse, and your client proximately caused that to happen. That sounds like a claim for child sexual abuse. It happened, you're the client's the cause. I mean, what's the difference between that and the claim against the perpetrator?
Well, I think it goes back to the contract analogy. You might have a claim. If I have a contract with Mr. Epstein here and someone interferes with that, I might have a claim against that individual for tortious interference with the contract. And I might sue them for that, but we would never say I was suing them for breach of contract. We'd say it was a claim for tortious interference. And I think the same analogy holds true here, where you have, and particularly because the court has to look at Section 4.2b, not just in isolation, but also against the way that the General Assembly has talked about these kinds of claims elsewhere in the statute.
But I mean, your argument, the analogy you just gave me would work much better if the language was a civil action for abusing a child. I mean, the thing is that it's worded in this way where it says for child sexual abuse. I think just in the ordinary English meaning of that, it seems to be encompassing this whole range of claims where the underlying event that happened was child sexual abuse, and then all of the possible claims that could be labeled as the cause of that having happened, which is broad enough to encompass the claims against your client.
Your Honor, I think that is a plausible reading if you only had to reckon with Section 4.2 by itself. And the issue here is that the General Assembly chose different language in Section 4.1 and 4.4 to talk about these kinds of claims. So, for example, in Section 4.1d, this is the part of the statute that extends the statute of limitations for go-forward claims, it raises it from what it used to be, age 21, to the new age of 28. And what the General Assembly said there is that a plaintiff may file a civil action against a defendant for claims related to sexual abuse suffered while the plaintiff was under 18 years of age until they attain 28 years of age. Similarly, Your Honor, in Section 4.2e, this is the part of the statute that revives claims following a felony criminal conviction for 2 years. And what the statute there says is that a plaintiff may file a civil action within 2 years of the date of a criminal conviction for a related felony sexual offense against a defendant for claims related to sexual abuse when the plaintiff was under 18 years of age. And so, while it might be possible to read in isolation Section 4.2 to encompass the kinds of claims Your Honor is describing, that's not the statute that the General Assembly gave us. They gave us a statute that talks about claims for child sexual abuse in one place, the revival of long-barred claims, and they gave us a statute that talks about claims relating to child sexual abuse in a different part of the statute.
So, my understanding, I'm sorry. In 4.3, which is the amendment to 1-56, the new section B says a civil action for child sexual abuse is not subject to the limitation in this section. So in your argument, that provision too is only limited to claim against the perpetrator of the abuse, and it's not governing the other claims?
Your Honor, I think the court, you would need to read it that way. It's the same language. And so, that's where the General Assembly uses the same construction in one place, under the rules of construction that the court applies, that reading should be, it should be interpreted consistently throughout the statute where the same words are used.
So this seems like a massively important distinction to a plaintiff. Can you sue just the perpetrator, or can you go after an employer or an organization? Why wouldn't we have expected the General Assembly, if it wanted to make that kind of really important distinction, to have done so more clearly?
Thank you, Justice Allen. I think that's an important question. And the court could, in really any case interpreting a statute, ask, is there a clearer way that the General Assembly could have done what it what it wanted to do. And we can see this in examples in other states that have enacted window legislation. Some states have enacted window legislation that explicitly provides that the statute applies both to the perpetrator and an employer who may be sued on a negligence theory. And so the question could be turned around, Your Honor, and say, if the General Assembly wanted to include those parties, why didn't it do that? And I think the question the court should ask is not whether there was a better way to articulate the policy aim that the General Assembly was going for here, but instead, what do the words that we have in the statute given to us mean, applying the canons of construction that the court applies to those questions?
So I want to go back to the question of, I understand you want us to conclude that for means something different than related to, but I want to go back to the question of why the claims against your clients in this case are not themselves claims for child sexual abuse. And it seems to me in your contract analogy, the true analogy would be a claim against a principal and an agent. And certainly, so the complaints do allege respondeat superior liability. And so if you're suing for breach of contract against an agent and adding the principal as the respondeat superior, it would still be a claim for breach of contract.
Well, I think that actually, Justice Earls, that's a very good question, but I think the theory of the complaints is not that the defendants are liable for the battery, because the law is very well settled that intentional criminal acts of an employer is not liable for the intentional criminal acts of an employee, which by definition are outside of the course and scope of employment. The issue here has to do with the employer's own alleged negligence in hiring the person or supervising the person. That's the theory on which these cases are asserted.
Well, but I also read in the complaints, I thought I understood claims that the employer was ratifying, condoning, facilitating, so it wasn't simply negligent hiring and supervision, but that they overcame and were responsible as respondeat superior because of the way they condoned and essentially facilitated the abuse.
Yeah, Your Honor, there could be cases like that where that's the theory. I don't think that is a claim for child sexual abuse as that phrase is used in the Child Safe Act. Again, going back to the distinction between 4.1 and 4.2. And I think you have to start with the premise that when 4.1 uses the phrase related to child sexual abuse, the term related to is about the broadest term we use in the law to describe the relationship between two concepts. And if that's the broadest term, and we agree that it is, it should cover claims against both perpetrator and employer under various theories of vicarious liability. But in order to be faithful to the canons of construction that this court applies, to give different words different meaning when they're used in the same statute, then for necessarily has to mean something less than relating to. It can't be quite as broad.
Well,
And
let me just, on these canons of construction, we only get there if we don't think the plain language covers this, right?
Your Honor, I don't agree with that in terms of the canons that talk about reading the statute as a whole, because that's part of the plain language analysis. When you go at what does it mean, you have to look at it in context.
And it is sometimes true that the General Assembly may use multiple words that essentially mean the same thing, right?
That can happen, Your Honor, and the question, presented in this case is that what the General Assembly tried to do here, or is there meaning behind the fact that the General Assembly chose to use different terms? And I think that to underscore that point, Your Honor, and while it's not this court's province to second-guess the General Assembly in terms of the policy decisions it made, it actually makes perfect sense that the General Assembly would make that kind of a distinction in the context of the revival provision that we're talking about here, in choosing to treat claims against the perpetrator defendant differently from those of an employer defendant. And it makes sense because the perpetrators themselves, not the organizations, are the ones primarily liable for the actual sexual abusive acts that happen for the reason I just described, that those are intentional criminal acts that are not within the course and scope of someone's employment duties.
I realize, or I think I heard you recommend that we not use the dictionary when looking at for, but if we do use the dictionary, specifically Webster's, we'll see that one of the definitions is with respect to or concerning, which sounds an awful lot like related to. Given that fact, I go back to my point. If the General Assembly wanted to draw this really important distinction that you're talking about, why shouldn't we have expected it to have done so more clearly? Especially, again, if these two terms are essentially synonymous, or can be used essentially synonymously.
Your Honor, I think the canons of construction that the court applies means that the court should not treat them as synonymous in this case. And while it may be that there are some dictionary definitions, again, these are both related to and for, can do a lot of work in the English language. And so there may be some definitions under which they are similar or arguably could be synonymous, but I don't think that's dispositive here, where you have a choice of the General Assembly to use different terms within the same statute in these two different provisions that have different goals. And so, the other reason that the General Assembly chose to treat these two kinds of claims differently, the perpetrator claims and the employer claims, is because of the evidentiary issues that exist when you're dealing with very old claims against organizations. And the court heard some about this earlier today, and I won't repeat all of that, but the difference between those types of claims and the perpetrator claim is that when you're dealing with a claim, plaintiff versus perpetrator, the case is going to turn on the credibility of the testimony as to those two individuals, and perhaps whether there's some other witness, but there often isn't. Whereas the claim against the employer, you're dealing with situations where there's no one around who can testify, there are no documents. And I say all this only to say that, again, policy is not the reason for the court to interpret the statute in a particular way. But the distinction that we're offering between the claims against the perpetrator and the claims against the employer has a sound policy rationale behind it, and it would make eminent sense for the General Assembly to draw that kind of line in terms of this statute and the way it treats claims differently. You can also see this in the fact that the General Assembly is reviving claims relating to child sexual abuse following a felony criminal conviction. Well, what's going on? If someone's been convicted of a felony, there's been evidence presented that beyond a reasonable doubt, they committed that crime. And it would be reasonable for the General Assembly to say, in that circumstance, we are not concerned about the evidentiary issues that might otherwise exist in a civil claim. And again, I say that just to underscore that the distinction we're offering has a sound policy rationale to it. It's not arbitrary or made up. Your Honors, lastly, if there was any doubt about the textual meaning of Section 4.2, then I think that the principle of constitutional avoidance dictates how the court should interpret it here. This is not necessary to our argument, Your Honors, but as we've heard this morning, well, it's not necessary to our argument, but it is a canon of construction that comes into play if the court has to choose between two different readings of a statute, right? Choose the one that doesn't present a serious constitutional question. And as we've heard this morning from our able counsel on both sides, there's a serious constitutional question about the application of the law of the land clause and about whether or not that precludes revival of claims that have been barred by the statute of limitations.
I hear what you're saying there, but the perpetrators of this child sexual abuse also, if that due process right or law of the land clause right existed, they would have it as well, wouldn't they?
Your Honor, I think they would, and that's just not this case.
We're not really, but I'm just saying we wouldn't be avoiding the constitutional problem if we tried to use constitutional avoidance in your favor, because we would still have the problem with the remaining people who are impacted.
You'd have it in a different case, Your Honor, and I appreciate Your Honor's point. We obviously made this argument as we were coming up through the court system and did not know at the time we'd be sitting here together, talking about these issues together. But I do think in terms of resolving this case, that is a reason that points to our interpretation of the statute. So I'd like to, in conclusion, Your Honors, I'd like to talk about why we think the Court of Appeals reasoning was wrong below. And I want to talk about 5 reasons. First of all, as we've discussed, the Court of Appeals analysis failed to appreciate the distinction between the phrases for child sexual abuse and the phrase related to child sexual abuse as used in 4.2 and 4.1 of the statute. Those are different terms that should be given different meanings under this court's precedents. And the Court of Appeals didn't really grapple with that issue, but instead just asserted that the claims, or that the terms for and related to did not need to be distinguished. It characterized this decision as one based on plain meaning, but failed to apply the interpretive canons that this court has endorsed. Second, Your Honors, the Court of Appeals mistakenly placed emphasis on the word any in Section 4.2 as a basis for its decision. But the word any is modified by what follows: any civil action for child sexual abuse, otherwise time barred. And it's that phrase, for child sexual abuse, otherwise time barred, that does the limiting work in terms of 4.2. And we cited an example in our briefs from General Statutes 141E-98, which is a statute that conveys immunity on hospitals in certain circumstances in any civil action for the release of an inmate's medical record, if that hospital complies with the Department of Adult Corrections requirements. But we would never read that provision to say that no suit against a hospital is allowed. We would say that a suit has to be about release of an inmate's medical record. And the question would be, what does that mean? Just as the question is, what is a claim for child sexual abuse in this case? Nor, Your Honors, I would submit it's not an answer to say, as the Court of Appeals did, that the General Assembly could have been clearer, and this gets to your point, Justice Allen. Yes, the General Assembly could have done it differently. And other states have done it differently, as I noted, making explicit that these revival provisions apply both to a perpetrator and an employer defendant. The General Assembly could have chosen to do that here. It didn't. And we're left with what the General Assembly gave us, the particular words of the statute here. Third, Your Honor, the Court of Appeals erroneously relied on its earlier decision in the John Doe 1K case, which is actually coming up next today and we'll hear about in a little bit. But what this Court of Appeals said in John Doe 1K is that claims were barred by res judicata, and it didn't address the merits of the SAFE Act arguments. And the Court of Appeals in this case below relied on a passing phrase in the Court of Appeals Doe 1K opinion to conclude that the revival provision covered the claims at issue here. We submit that was error, and the Court of Appeals should have gone through the textual analysis that we've undertaken in our briefs. Fourth, the Court of Appeals said that giving for and related to different meanings would lead to absurd results. But, Your Honors, I would submit that's not true either because of the reason I articulated earlier. There's actually a good policy reason to treat those claims differently, given the relative fault and given the evidentiary concerns that exist with pursuit of such claims against employer defendants. And finally, the Court of Appeals failed to apply the doctrine of constitutional avoidance, and I understand Justice Dietz's point, but the Court of Appeals did not use that canon in interpreting the statute as it should. So, in conclusion, Your Honors, we would ask the Court to reverse the Court of Appeals, and unless the Court has any further questions, I will stop there and let my friend take it up from here.
Thank you, counsel. Hear from the appellee.
Mr. Chief Justice and members of the court, may it please the court, my name is David Stradley of the Wake County Bar, and I represent plaintiff Gregory Cohane in this matter, along with my colleague Leto Copley of the Orange County Bar. (1-52), 4, trespass upon real property. 4, taking, detaining, converting, injury, or any goods or chattels. 4, recovery of any amount under the Fair Labor Standards Act. 4, recovery of taxes. 4, recovery of an unlawful fee. 4, assault and battery or false imprisonment. 4, usury in 1-53. 4, relief not otherwise specified, 1-56. 4, damages caused by construction of a railroad against a terrorist. 4, damages under GS 1-539.2D. everywhere one looks in North Carolina's limitations chapters, one finds the word for. So it should surprise no one that when the legislature decided to open a window for victims of child sexual abuse to pursue justice, that they used the word for. Now, I want to take us back, for my first point, I want to take us back to grade school. Some of you may remember this. Please excuse my dear Aunt Sally. And it's the mathematical order of operations, if you remember that. You got to, when you do a math problem, you got to do it in a specific order. And if you don't do it in a specific order, what happens? You get the wrong answer. Well, you know, this court has said statutory interpretation kind of works the same way. As Chief Justice Newby said in the Farm Bureau versus Hebert case, if a statute's plain language is clear and unambiguous, this court applies the statute as written, and this is the important part, does not engage in further statutory construction. This court may turn to other sources to determine legislative intent only if the statute is ambiguous or susceptible to multiple interpretations. So there's an order of operations in statutory interpretation, just like there's an order of operations in 8th grade math. And if you do it wrong, you don't do the order of operations, you get the wrong answer. And my friend here is urging this court to ignore the order of operations and get the wrong answer, because the order of operations does not give my friend the answer he is looking for. The statute in this case, as I believe Justice Dietz pointed out earlier in this argument, is crystal clear. Any reasonable English speaker in this that reads this statute would know what it means. The argument that you got to go hunting through other parts of the statute is an argument only a lawyer could love. Now, why do we have this rule, primary rule of statutory construction? And one reason we have it is to prevent all sorts of judicial mischief, right? I mean, if we just go interpreting statutes that don't need any interpretation, judges can do all kinds of things that perhaps judges don't have any business doing. But I'd submit to you there's another reason, and maybe a more fundamental reason, that we look to the plain language first. And that is because laws are written for people. They're not written for lawyers. You know, we lawyers sometimes sort of like to elevate our importance in things, but at the end of the day, the legislature over on Jones Street isn't writing laws for us. They're writing laws for the citizens of North Carolina. And you shouldn't have to go to law school to understand what the law is. And that's why this court has repeatedly said you don't have to go to law school to know what the law is if you can look at the law on its face and know what it means. And I would submit to you that in this case, when the legislature said it opened a window to revive any civil action for child sexual abuse, otherwise time barred under GS 1-52, that could not be clearer. They could not have done any better than that. Because as...
let me push back on that, because just to be fair to your friend, you know, if you stop someone on the street and, you know, they're rushing in with their lawyers into the courthouse and they say, what are you running to court for? And they say, well, I'm getting hauled in here for child sexual abuse. And it turns out you'd been sued for negligent supervision of someone who committed those acts. When the person you told that to discovered that, they would feel like you weren't very accurate in what you said. I mean, that doesn't sound like you're racing into court to face allegations for child sexual abuse, you know, that sort of thing. So it seems to me your stronger argument is just there's no such thing as a civil action for child sexual abuse, and we just need to try to understand what the scope of that then means.
That's certainly a winning argument as well, Your Honor, and you're correct. There is no such thing as a common law claim for child sexual abuse, but you know, the legislature helped us out with that. Again, they talked about otherwise time barred under 1-52. Well, we got some help with that. Because this is what 1-52 looked like before the Slave Child Act. And we know that these are claims for any other injury to the personal rights of another, assault, battery, false imprisonment, or for personal injury, to name a few. There's more than 19 subsections of 1-52, but the fact of the matter is we got 3 requirements. It is a civil action for child sexual abuse, otherwise time barred under 1-52, and these are the things that qualify under 1-52. So we know what those types of actions are, and we know that 1-52, for example, is a statute which covers general personal injury claims. And we know that a claim for negligence is covered by that, whether it is negligence of the truck driver or the trucking company, or the nurse, or the hospital, or the principal, or the agent in whatever context we're talking about. So again, the legislature, pretty clear when they say, well, look at 1-52, those are the kinds of claims we're talking about, and those are the claims for which there's a window. Now, and so getting back to the order of operations, we've got to have an ambiguity before we get to any of these other rules, in pari materia, any of that stuff. And an ambiguity, as best I could find a definition, at least according to Scalia and Garner, says there have to be 2 almost equally plausible definitions, or two almost equally plausible readings. And
It's interesting that you pick up that book to make the point, though, because doesn't Justice Scalia say that considering statutes in pari materia, invoking the canons of statutory construction, you know, to sort of have all these Latin phrases that help you, that is part of determining whether the text is plain and unambiguous?
even if Justice Scalia does say that, Justice Scalia doesn't sit on this court and didn't write any opinions for this court, and this year, this court said this is the rule, that we look first to the plain language and we don't look to any of these other doctrines, and they're a long line of cases.
But let me give you an example of why I think Chief Justice Newby was channeling his inner Antonin Scalia here when he said that. So if you say you have to look at the plain language of a statute, and then 4 sections above that, there's a definition of several words that are used in that statute, you would absolutely say I need to look to that provision to understand the meaning of this provision. So many of these canons of statutory construction are just grammatical canons that help us understand what the meaning of the English language is, and you could certainly consider all that in that first step that you're talking about. It seems to me.
Absolutely, and if we had a definition of for in the statute, we would absolutely need to consider that, but we don't. Which brings me to a related point, which is this notion that we have to give different words in the statute, different meanings that Justice Allen raised. And the case that is cited for that is the N. Ray MIW case, which is a case about the distinction between having jurisdiction and exercising jurisdiction. And those two words are clearly different. They clearly mean different things. A court can have jurisdiction, as this court pointed out, without exercising that jurisdiction, and those are not synonyms. On the other hand, when the legislature uses synonyms, then one certainly should give those terms the same meaning, unless there's some really, really sound reason to do otherwise. My friend eschews, I think that's the way you pronounce that word, the dictionary in this case. And the reason he eschews the dictionary is because he can't point to a single dictionary definition that helps him out here. His definition of for is for the purpose of. Well, it's clearly that there's certainly no civil action for the purpose of child sexual abuse. Nobody's going to court to get to abuse children sexually. So if there's just no definition of for, and, you know, while the dictionary may not be the exhaustive source, it's certainly a darn good place to start, and they don't point us to any other other place to look. It's certainly, there's simply no definition of for that draws the distinction they wish to draw, which brings me to this other notion of, we talk about a plausible other meaning.
I wonder if to some extent, your reliance on 1-52 hurts you a little bit, because, as you pointed out, it does use the preposition for repeatedly. And so, for example, for trespass upon real property. Well, surely that doesn't mean related to trespass upon real property. That means the tort of trespass upon real property.
And as Justice Dietz points out, that's because there is a tort of trespass on real property. And again, we're not talking about for child sexual abuse. That's not all the legislature said. The legislature goes on to say it's for child sexual abuse and time barred by 1-52, i.e. these kinds of claims.
So for has a strict meaning in 1-52, but in this provision it has a looser meaning.
Well, I think in this provision, it means related to child sexual abuse with time-barred claims. So time-barred claims related to child sexual abuse, which is this, or for child sexual abuse. Either way one slices it. But I think a key point is a point that you raised, Justice Allen, which is this notion that if the legislature had intended this momentous distinction between liability for perpetrators and liability for institutional defendants, they surely would have given us more of a clue rather than doing it sort of on the down low, as they say, by the distinction between for and related to. Again, a distinction we don't get to unless we believe the statute's ambiguous in the first instance. There is simply no way that the distinction between for, the thin reed of distinction between for and related to can possibly bear the weight of the distinction that the defendants want to place on that in this case, because it makes a big difference. It makes a big difference as to who is liable. It makes a big difference as to who is going to be deterred by these types of actions. And if the legislature meant that, they surely would have told us that rather than relying on clever lawyering to come up with this notion that, oh, we only intended to protect, we only intended to hold perpetrators liable as opposed to institutional defendants. But even if we ignore the primary rule of statutory construction and go to in pari materia, that just takes us back to, I mean, these are statutes of limitation. That just takes us back to the use of for in all these limitations provisions. And what we see is it, you know, it applies, this is the kind of thing that the legislature uses. And the Morris case is an excellent example of that because it's exactly what the court did. The question in the case required the court to construe 1-15 with 1-17, two statutes of limitations. And the court said that you construe them all together when they relate to the same matter or subject. Well, again, all of these statutes of limitations use for throughout them. So the notion that for somehow only applies to direct perpetrators could wreak all sorts of havoc in our jurisprudence. For example, if actions for only apply to the direct perpetrator, that means that GS 1-56 applies to all other claims. So that means that would have the bizarre result of saying that the truck driver gets a 3-year statute of limitations, but the trucking company has to live with a 10-year statute of limitations. The hospital has a 10-year statute of limitations, while the doctor or nurse gets a 3-year statute of limitations, if that's what for means within our statutes of limitations.
I think you're getting to this, but Angie, the statutory language doesn't reference who might be liable at all.
That is
right?
correct, Your Honor. There's nothing in there that says liability, a particular type of defendant for child sexual abuse.
And the second question I have is, isn't there a distinction between a statute that's broad and a statute that's ambiguous? And the fact that it's broad doesn't turn it into an ambiguity.
That is exactly right, Your Honor. The legislature is absolutely free to write statutes as broad as it wants to, provided it doesn't run afoul of the Constitution. And under Harper versus Hall, a specific provision of the Constitution, it can write statutes as broadly as it wishes. That does not make them ambiguous. And again, the only way that they even get to the first step of their argument is by comparing the language of 4.2 with some other provision of the statute, which again contravenes rule number 1 of statutory interpretation. Another odd result that the defendants actually acknowledged from their interpretation in argument here today is that if they're correct, while the window statute would not apply, the statute that opens up claims after a criminal conviction would apply to institutional defendants, which again is odd, because just because there has been a criminal conviction doesn't mean that the institutional defendant is in any better position to defend against those claims. So that would be an odd policy choice by the General Assembly, certainly one they could have made, but an odd result. Briefly, on the point of constitutional avoidance, as Justice Dietz points out, this is at best an example of constitutional kicking the can down the road, not constitutional avoidance, because the constitutional issue would apply likewise to the perpetrator, just like it applies to the institutional defendants. I won't delve into the constitutional issues. Those were adequately treated by the folks before me. So in conclusion, from our perspective, the court should affirm the ruling of the Court of Appeals, reversing the dismissal on statute of limitations grounds, and I will yield the remainder of my time to Mr. Ellis from the Department of Justice.
Thank you, counsel.
Mr. Chief Justice, Associate Justices, good morning, and may it please the court. My name is Trey Ellis. I represent the state of North Carolina, and I would like to thank the court for allowing the state the opportunity to present argument as amicus in this appeal. In my short time, I'd just like to emphasize one point. If the General Assembly intended to distinguish between individual perpetrators and institutional defendants, it would have done so in the plain text of the revival provision of the Safe Child Act. And it could have done so, but it did not. And because it did not, it is the state's position that the revival provision covers any civil action for child sexual abuse, regardless of the identity of the defendant, and the state respectfully requests that this court affirm the decision of the Court of Appeals. First, I'd like the court to consider a few things as it undertakes interpreting the revival provision. First, to reference a famous canon that comes from Justice Scalia, legislatures do not hide elephants in mouse holes, meaning legislatures do not place important fundamental details of a statutory scheme in vague or ancillary provisions. So here, if the General Assembly truly intended to distinguish between individual defendants and institutional defendants, it would have done so expressly in the text of the provision and would not have hidden such a significant policy choice in the very slight textual distinction between for and related to. And this is actually what the Court of Appeals concluded in their opinion, that if the General Assembly's intent was to draw that distinction between individual perpetrators and institutional defendants, it would have done so explicitly in the text of the provision and would not have ensconced such a crucial difference between the word usages of for and related to. I'd also like the court to consider how other states have handled this exact issue. As we cite in our brief, revival provisions from other states show that when legislatures have sought to distinguish between individual and institutional defendants, they have done so expressly in the provision. For instance, under the revival provision drafted by the Georgia legislature, stated that lawsuits involving otherwise time-barred claims for child sexual abuse could only be brought against the individual alleged to have committed such abuse. And likewise, the Rhode Island legislature limited its revival provision to cover only a perpetrator defendant. So these examples from other states show how easy it is for a legislature to distinguish between direct abusers and other possible classes of persons or entities that could be defendants. But the North Carolina General Assembly did not do that in this revival provision. And so with this explicit limitation showing up in the revival provisions of other states, it comes as no surprise that state courts in other states have rejected the argument that defendants are now asserting to construe a limitation to direct perpetrators when such a limitation is not in the actual text of the provision. More specifically, as we note in footnote 4 on page 13 of our brief, other state courts have held that when a legislature has chosen to expand its statute of limitations for claims of child sexual abuse without expressly excluding institutional defendants, which is the case here, it is presumed that the legislature made that choice deliberately. And so here, the difference between for and related to is not enough to overcome that presumption. So the state asks the court to maintain the remedial and protective purpose of the Safe Child Act to afford the greatest possible protection to innocent victims of child sexual abuse. And if there are no questions from the court, in conclusion, the state respectfully requests that this court affirm the decision of the Court of Appeals and hold that the Safe Child Act's revival provision is not limited to direct perpetrators of child sexual abuse. Thank you.
Thank you, counsel. Rebuttal.
Thank you, Mr. Chief Justice. Briefly, to respond to some of what Mr. Stradley had to say, he wants the court to focus on a lot of uses of the word for outside of the Safe Child Act, in Section 152, in the dictionary, other places. But what the court needs to do, we would submit, is look at how it's used in the statute the General Assembly gave us. There's no dispute that for is a common term, but the General Assembly gave us a statute that in one place talks about claims for child sexual abuse, and in other places talks about claims related to child sexual abuse. We think that decision to use different terminology was intentional and should be given effect. Mr. Stradley also talked about the order of operations, and I guess his argument is that we can't look at other provisions of the Safe Child Act, on the first pass unless the court finds an ambiguity, but I would respectfully submit that's wrong for the reasons Justice Dietz identified. That's part of interpreting the statute, and the quotation he read from this court's decision, I noted, talked about turning to other sources. What the court's talking about there is recourse to sources outside of the statute being interpreted. But that's not what we're asking the court to do. We're asking the court to look at the four corners of the law the General Assembly gave us, and that's part of the first step of interpreting the language before the court. In response to Mr. Ellis's arguments, again, he argued that if the General Assembly wanted to make this distinction, it could have done so more clearly. This is not, I would submit, an elephants and mouse hole situation, Your Honors. This is a situation where the General Assembly made a distinction in terminology. And again, because there a clearer, more explicit way of doing that? There's probably many. But the fact is that the General Assembly did not choose to explicitly include claims against employers, as other states have done. And I think that was a meaningful choice that we would ask this court to give effect to. So in conclusion, unless the court has any further questions, we would request that the court reverse the decision of the Court of Appeals. Thank you.
Counsel? Thank you.